This is the issue, and I am the ghetto man. Today's issue, the Bill of Rights, the Second Amendment. Can the Second Amendment be amended or repealed? Don't go away. We'll be right back. Recently, there's been a lot of talk, especially by the Democratic Communist left, about repealing the Second Amendment. I'm really having a hard time wrapping my brain around the ignorance surrounding the meaning of the Bill of Rights. And when I say the Bill of Rights, I'm talking about the first 10 amendments to the U.S. Constitution. There are people in this nation today that actually believe that the Bill of Rights can be amended and or repealed. Well, that's a good question. And that's what this video is all about. That's what this show is all about. Can the enumerated rights in the Bill of Rights be amended and or repealed? Okay, the rights that are secured by the Bill of Rights existed long before the U.S. Constitution was even a twinkle in our nation's founders' eyes. The rights enumerated in the Bill of Rights are so fundamental that they exist whether there is a Constitution or not. Why? Because these rights are inalienable rights. Rights that belong to you just because you're a human being on planet Earth. A gift from God to some and a gift from nature for others. These inalienable rights are yours and yours alone. They are so fundamental that government is forbidden to alter or abolish them in any way. Well, let me explain. Let's take a look at the Bill of Rights. As I said earlier, the Bill of Rights are the first 10 amendments to the U.S. Constitution. The first thing that we must understand, and this is so important, is the U.S. Constitution did not create any of the rights contained or enumerated in the Bill of Rights. They're inalienable rights. And as defined by Black's Law Dictionary, the 5th edition, rights which can never be abridged because they are so fundamental. All of the rights contained in the first 10 amendments, including the inalienable right to keep and bear arms, exist independent of the Constitution. In other words, the rights enumerated in the Bill of Rights are independent from the amendments themselves. Now let that sink in for just a moment. The rights enumerated that are listed in the Bill of Rights are independent from the amendments themselves. Not one right contained in the Bill of Rights was created by the Bill of Rights or created by the Constitution. The preamble to the Bill of Rights, yes, the Bill of Rights has a preamble, and that preamble makes the intent of the framers as clear can be. Let me read the first paragraph from the preamble. The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. And as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Like I said, that's the first paragraph of the preamble to the Bill of Rights, which was ratified by the states December 15th, 1791. The states were concerned that the federal government might not honor these pre-existing rights. So a Bill of Rights restricting the power of government to abridge these rights was adopted. The Bill of Rights are declaratory and restrictive clauses, and they're directed towards government only and do not create or grant the rights that are enumerated within them. Had the Constitution granted these rights, the word granted would have appeared in the law. Instead, we find in every amendment the words nor, no, and not. That's what appears in the law. Let's see what the U.S. Supreme Court has said about the issue. In the Supreme Court case, United States versus Cruikshank, it's an 1875 case, can be found in the United States Supreme Court Reports, Book 92, and the case starts on page 542. The court ruled that the rights enumerated in the Bill of Rights are not granted by the amendments. You really got to get a hold of this, because until you understand that the rights themselves supersede the Constitution, you're not going to be able to really understand what I'm trying to teach you here. You see, the court also ruled that the rights enumerated in the Bill of Rights are not dependent upon the Constitution for their existence. And why? Because we're talking about an inalienable right here. An inalienable right exists outside of the U.S. Constitution's jurisdiction. The court made it clear that the amendments were restraints on the powers of the federal government, not on the individual rights of the American people. Have I gotten your attention yet? Okay, let's take a look at the court's reasoning here. Let's look at what I think is the most definitive and succinct legal explanation of the Bill of Rights and the Second Amendment there is. I feel that this quotation is especially appropriate because it is directed to the right to keep and bear arms. Okay, quoting from the court. Now listen to this wording. Quote, the right there specified is that of, quote, bearing arms for a lawful purpose, unquote. This is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more that it shall not be infringed by Congress. Now listen to this wording of this last sentence here. This is one of the amendments that has no other effect than to restrict the powers of the national or federal government. Be found in the case called United States versus Cruikshank. It's an 1875 case. It can be found in the United States Supreme Court Reports, Books 92, on page 542. You see, the court understands that the Second Amendment did not create or grant the right to keep and bear arms. The court also understood that that right supersedes the Constitution altogether. All that the Second Amendment did is place an additional restraint on the powers of the federal government concerning the existence of the inalienable right to keep and bear arms. Even if the Democratic Communist left could repeal the Second Amendment, which they can't, all it would do, if it could do anything at all, is remove the secondary restraint imposed on the federal government by the amendment. The right to keep and bear arms still remains, and it remains forever. Forever. And since many of the 50 states have the right to keep and bear arms as part of their Constitution, the existence or non-existence of the Second Amendment's secondary restraints would not have any effect on the right of the people to keep and bear arms, especially within their respective states. In fact, repealing any of the first 10 amendments would not affect or eliminate any of the rights enumerated in them whatsoever. Why? Well, you already know that answer. Because the rights contained in the first 10 amendments were not created by the amendments. this is one of those nasty little checks and balances that our nation's founders enacted. They were a lot smarter than those people who would like to subvert our Constitution, our freedoms, think they were. Now, I'm going to deal with Article 5 here, because I hear this argument all the time that Article 5 allows the government to amend or repeal a constitutional amendment. Article 5 of the Constitution deals with the amendments to the Constitution. There is no authority under Article 5 granting Congress the power to amend or repeal a right or law that the Constitution did not create. The Bill of Rights did not create the rights enumerated within them. The Bill of Rights only created the restrictions on the government from tampering with those rights. So the Article 5 argument is clearly without any merit or foundation in law whatsoever. Now, one more thing. Another one of those nasty little checks and balances that our founding fathers put in the Constitution. One that I don't know why, but it seems like everybody seems to forget and ignore. And it's very important because it really puts the cap on this issue of whether or not the Second Amendment can be amended or repealed. And you know what that is? That's the oath of office. Before a public servant can take office, that public servant has to take an oath. And the oath goes like this. Listen to it very carefully. I, whoever, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. That I will bear true faith and allegiance to the same. That I take this obligation freely without any mental reservation or purpose of evasion. Very important. Without any mental reservation or purpose of invasion. Remember that. And that I will and faithfully discharge the duties of the office on which I'm about to enter. This is before you enter. This oath is before. So help me God, or affirmation or whatever. Okay, when a public servant takes an oath of office, that public servant agrees to support and defend the Constitution of the United States, which includes the Bill of Rights, doesn't it? A public servant cannot take an oath that requires them to obey the restrictions contained within the Bill of Rights and then violate that oath by moving to repeal those restrictions after taking that oath. To do so would be in violation of the oath. It'd be in violation of their oath of office. It would be perjury. It would be treason. You see, it is an act of treason for any public servant to even suggest that any of the rights enumerated in the Bill of Rights be altered or abolished. Remember, the oath to uphold and defend the Constitution takes place before the public servant takes the job. It isn't the other way around. And once you take the oath, you are bound to it by law. You are bound to uphold and defend the Bill of Rights before you even start the job. After taking that oath, anything that you do to the contrary is a crime, an act of treason. You can't move to amend or repeal the Bill of Rights after you swear an oath to defend them. It doesn't work that way. As you can clearly see, based on the law, based on the intent of the framers, based on Supreme Court rulings, and based upon U.S. history, none of the inalienable rights that are secured by the Bill of Rights can be amended or repealed under any circumstances. So the next time some traitorous democratic communist leftist cuck tells you that the Second Amendment can be amended or repealed, what are you going to tell him? I am the Ghetto Man. Thank you for watching. If you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. Please subscribe. Please share. Long live the Republic.